So let me get things started. I'd like to acknowledge and celebrate our First Nations people and pay our respect to the elders past and present. I also like to acknowledge the traditional custodians of the land on which the ANU is located, although we're probably not, perhaps not all of us are in Canberra at the moment, the Ngunnawal people. I'd like to welcome our two speakers, Professor Gabrielle Appleby and Professor Megan Davis, who will join us shortly. Both Gabrielle and Megan will be very well known to you all, so I won't take up time going through their extensive bios. Gabrielle and Megan are about to, or probably have already, embarked on a new project that looks to interrogate the rule of law, successes and failures in Australia, particularly from the lived experiences of First Nations people. And we're very lucky to have them join us for our lunchtime seminar to tell us a bit more about their projects and, hopefully have an opportunity for a conversation about the ideas that they're looking to explore. So, Gabrielle, over to you.
Thank you so much, James. Thank you for this invitation to come and speak to ANU. I had hoped to come and be there in person, but obviously circumstances have not allowed that. But nonetheless, it's lovely to see so many familiar names and a few faces on the screen. I'll also start by acknowledging that I'm calling in from the lands of the Mawanina people of the Hobart region down here in Lutruwita, Tasmania. Pay my respect to their elders, and I recognise and I remember the tragic history of violent dispossession during colonisation and invasion in the 19th century here. And I pay my respects to the Palawa people of Lutruwita today and extend my respects to any Aboriginal and Torres Strait Islander people who are joining us on this call. So, as James indicated, today I'm presenting the core ideas and structure for a book proposal that I'm currently working on with my colleague and friend, Megan Davis. And Megan has just been caught in another commitment, but she will be joining us as soon as she is able to, and she sends her apologies in the meantime. So just a little bit about the series that the book is going to form part of as the Australian title. So the proposal that I'm going to speak to you about today is in a new series by Hart called The Rule of Law in Context. And the book series is intended to be one that considers the rule of law on its own terms and explores different meanings, uses and instantiations across the world's legal systems. So it's aimed at developing a deeper understanding about this concept of the rule of law as it's used, as it's operates in different jurisdictional contexts, how it might be achieved or not according to its own terms in those contexts. So the series explores conceptualisation, deployment and instantiation of rule of law in different jurisdictions around the world. The intent of the series is to make an original contribution to rule of law scholarship by moving past the sort of somewhat intractable normative debates over what the rule of law should mean to find out what it actually means, how it's being deployed by governments, by other actors in legal systems, how it operates on the ground. So the series has an implicitly comparative objective as it explores these ideas in the context of different legal systems across the world. In claiming to provide a contextual analysis, the titles in the series are directed towards placing the concept of the rule of law in historical context, explore the role of history in different moments in shaping and informing the domestic understanding and levels of protection for rule of law institutions and principles, to explore legal and political factors that contribute or detract from rule of law achievements, to consider non-legal and non-political factors that affect rule of law achievements, to narrate the lived experience of rule of law in each country, including domestic discourse around the concept, how it's being used, and finally to identify international factors that have affected the country's relationship to the rule of law. So these are kind of our writing instructions for the series that we are developing this proposal in. So as I've indicated, Megan and I are preparing the Australian title for the series, And what we're presenting today is a proposal in its formative stages. We were urged to do so by James when he reached out to me about what I'd like to present to this series. We've done a lot of reading, thinking, conceptualising, reworking, but we do still think it can be improved and tested with others, and that's certainly the intent that we bring the paper to you today, and we're really looking forward to hearing your comments and feedback. So a book on the rule of law in context and its jurisdictional contests feels like a title that is of particularly high relevance right now in Australia. And this is for a whole host of reasons. As legal practitioners and academics, this year we celebrated the 70th year anniversary of the Communist Party case, with conferences, with seminars marking the landmark decision that established the rule of law as an assumption of our constitution. Although, as the High Court reminded us just last week in the most recent Palmer and Western Australian case, the limits of the concept as a judicially enforceable, free-ranging constitutional principle. This year, we also saw the rule of law used defensively by the Prime Minister in relation to the then Attorney General, Christian Porter, against calls for an administrative inquiry into the allegations of rape against Mr. Porter, in distinction to a possible criminal trial for Mr. Porter, which, with the death of the victim, was not likely to occur. There were subsequent challenges to the Prime Minister's invocation from academics across public, criminal and international law. Last year, we also saw administrative findings of sexual harassment against the High Court jurist, perhaps most famous for invoking the rule of law in the last generation, Dyson Heydon, and a call by more than 500 women in the law for the establishment of a new legal institution designed to bring to account federal judicial officers, to bring rule of law to the guardians of it. And this year, we've also marked and mourned the passing of the 30-year anniversary of the Royal Commission into Aboriginal Deaths in Custody. 3 decades on, Aboriginal and Torres Strait Islander adults are still incarcerated at 13 times the rate of non-Indigenous people. Nearly 500 Indigenous people have died in custody since the issue of the report. Those numbers, those people, those lives makes concepts such as the rule of law ring particularly hollow, not just for First Nations people in our country, but for the entire Australian community. So this title is going to engage with each of these contemporary examples and many others, but it's not intended to be a reflexive title, but rather to be an attempt to be historically contextual and comprehensive in its analysis of rule of law discourse and lived experience in Australia. So the book is going to attempt to investigate some core legal, political, cultural myths and assumptions of the Australian nation by canvassing, challenging and recasting some of the well understood debates around and invocations of the rule of law. Australia, as an established liberal Western democracy that is economically prosperous, politically stable, has consistently ranked well, within the top 15 indeed, of international rule of law indices. But it is not the intention of our book, and it's not the intention of the series, to assess the Australian position by reference to some established or even some new normative rule of law index. Rather, the intention of the book is to understand how rule of law is conceived in Australia, when it's engaged, for what purposes, whether it's perceived as being met, and whether and where are the key points of contestation. So the book has 3 aims. I'm going to go through them now. And in the course of that, I'll set out how we're going to hopefully substantiate some of our arguments. So the first aim, we want to provide an analysis of the concept of rule of law as it's deployed and contested in the Australian legal and political spheres. So certainly Australians espouse enormous amounts of rule of law rhetoric in these spheres, domestically as well as internationally. And we start in the book by looking at appeals to the rule of law in Australian scholarship, and particularly we look at it in 3 areas. We look at scholarship on colonial era reforms, particularly to the judicial and legal system that have been heralded by commentators as rule of law achievements. And so here we're looking particularly at the work of scholars such as Alex Castles, Neil Windier. Next, we look at those scholars that look at constitutional rule of law protections, particularly but not exclusively following the Communist Party case, what that means for rule of law in Australia, and cases such as Plaintiff S157. And then we look at the invocation of rule of law in the where there's a focus on the defence of the Australian High Court's commitment to judicial legalism, particularly in the face of realist challenges to the veracity of such an approach. So within this Australian legal scholarship, we see an acceptance and defence of a formalistic rule of law, which is protected at least in part by our constitutional system, as well as the critique of that system and its shortcomings by a group of scholars who adopt a thicker and more substantive conception. So in some respects, you could just say the Australian rule of law debate that becomes evident in this scholarship is another example of the contest between those advocating for a thicker conception of the rule of law and those for whom the rule of law encapsulates only a basic formal definition that might be described as thin. But of course, the thin and thick conceptions do not represent two simple positions. They're highly individualised and historically contingent. However, at the heart of this polarised contest is whether the rule of law extends to the more expansive, substantive legal protection of the rights of individuals within society, or whether it should be limited to a more formalised and procedural set of requirements within the legal system. In Australia, we'll show that this contest is certainly alive and well. There's a generally accepted landing place that's described by leading constitutional lawyer Professor Cheryl Saunders, that constitutionally, the Australian conception of the rule of law is procedural rather than substantive, thin, not thick. And this is undoubtedly the conception of the rule of law that colonial historians use as their yardstick in the development of the rule of law in Australia. It's the form of rule of law that the Australian High Court refers to in its jurisprudential references to the rule of law, and as much was confirmed last week in the Palmer decision. But it's not just descriptive in the Australian context. It's the conception that is invoked by conservative legalistic jurists and others to attack more progressive interpretive approaches. Since the 1990s, conservative jurists and commentators have successfully deployed the label of judicial activism against more progressive judicial turns, particularly where those result in the protection of rights. This activism, they claim, is a threat to the rule of law, or at least some of them claim. The concept is deployed as an attack on those seeking access to the legal and political system by minority interests. So we'll look in the book at formalistic claims to rule of law that emerge in Dixon's legalism, Sanini and Stevens' explanation of the rule of law, Murray Gleeson's Boyer lectures, and Dyson's Hayden's attack on the judicial activism of the Mason Court. We're then also going to look at how the rule of law has been developed by those advocating for a more substantive understanding of the rule of law and greater legal protections in the Australian state and constitution, such as Michael Kirby. Here we'll also examine criticisms made by jurists such as Sir Anthony Mason of the conservatism and protection of established values of concepts such as legalism. In this respect, we'll trace the scholarly arguments advanced by Julius Stone and the conception and criticisms levelled by Geoffrey de Q. Walker. So another view of the rule of law that we see in the scholarship is that developed by leading Australian rule of law scholar Dr. Lisa Burton Crawford, and we also see it in the writings of former Chief Justice of the High Court, Robert French. And this is that while the constitutional protections or manifestations in Australia might reflect a particular version of the thin conception of the rule of law, there are more substantive elements of the rule of law evident across the Australian system. These are, for instance, protected through legislative enactment. That is, they are entrusted to Parliament to determine. So it's Parliament as the people's representatives who speak through legislation, the law. Thus, the turn to the rule of law in Australia can become firmly planted in our commitments to democracy. This then goes to a further dimension of the rule of law debate in Australia. And this relates to the role of the judiciary and the Parliament in the constitutional system, specifically with regard to how they contribute or provide the foundation for rule of law claims. is, as A.V. Dicey posited in the second half of the 19th century, the sovereignty of Parliament the foundation for legality. The law might be supreme, but it's the sovereign power of the Parliament to determine the law. Or are there or should there be substantive limits on the Parliament's powers enforced through the judicial branch that provide the foundation for our rule of law system? The argument, for instance, associated with T.R.S. Allen's common law constitutionalism. This takes us to another foundation of the Australian state, this deep belief in and defence of majoritarianism. If we go back to Dicey, we see the idea that law is legitimised through majoritarian democracy. When it was suggested at Federation that the new Australian Constitution might protect due process rights of individuals within it, it was rejected for two key reasons. These help us understand, we say, some of the contemporary debates over the scope of the rule of law. The first is that the colonists were establishing government for a particular society, one that was not intended to extend legally enforceable rights to others. At that time, Aborigines, Chinese, Afghans, and South Sea Islanders. The second reason was in keeping with the first, that the rights of the people of the new polity would be adequately protected by the democratically elected parliament. And this gives rise to the rarefication of democratic institutions and trust in democratic authority and checks to achieve the common good. While there is cultural acceptance of the supremacy of judicial review, it's in a limited form with the distrust of the judiciary beyond its role in policing necessary governance boundaries established by the Federal Constitution. The rule of law in Australia and the debates around it, therefore, is intricately linked to the practice of democracy and the inclusion or the exclusion of voices from that process. For instance, as Justices Gummow and Bell explained in the Roe decision in 2010, whatever else it involves, the rule of law in Australia posits legality as an essential presupposition for political liberty and the involvement of electors in the enactment of law. It's these two relatively conventional and well-trodden contests around the rule of law, thick versus thin and parliamentary sovereignty versus judicial review, that are predominant in the description, commentary and teaching of rule of law in Australia. But understanding the rule of law in Australia as giving rise only to these contests misses, we argue in the book, two key things. First, it misses an understanding of the social and political aspects of the rule of law in the country, and thus it undervalues the need to look beyond the courts and understand the political actors and institutions, civil society, NGOs, media and the public to appreciate the spectrum of achievement or failures of rule of law. I'm going to return to this because this is a whole separate aim of the book. The second thing it misses, though, is an understanding of how the concept of the rule of law is used as a legal and political weapon in Australia in a deeper ideological contest for the foundation of the constitutional system. And we're going to argue this contest is occurring at a number of levels. We will explore the increasing political use of the concept of rule of law. It has been adopted in its more substantive sense by progressive opponents as a criticism of actions and schemes that push the boundaries of legal and constitutional norms, so that commentators claim that there are failures of rule of law in relation to a whole host of institutional failures. On the other hand, we see it co-opted into the conservative lexicon in its defence of tough on crime measures and in the last couple of decades in relation to national security responses, many of which progressives have themselves attacked on thicker rule of law bases. So we see the rule of law conversation directly coming into conflict. It's also arisen in the conservative defence of property rights and its pursuit of regulatory stability to encourage economic growth, connected in many respects to a wider conservative agenda in relation to traditional common law rights. So this book is also going to explore the idea that the contest that can be identified in Australian rule of law debates, including whether Australia meets or even should aspire to a concept of rule of law as thick or thin, or a legal political blend of the two, is in many cases only the surface of what is happening. And rather, at the heart of the rule of law contest, what's actually occurring is, on the one hand, people using the rule of law to defend and promote established political and economic interests. And on the other hand, the complex concept is being used in the arsenal of those trying to force open access to power and protection to previously excluded minority interests. So we have fundamentally opposing appeals to the same concept, and particularly when it's occurring in the political and public debate. So the deployment of the concept of the rule of law in these deeper debates does not pull against each other in a linear direction. Rather, what we think is happening is that those who might be subjectively referring to the rule of law in its more formal form are able to cloak arguments, so create a veneer for arguments that are for established interests in this more substantive conception of the rule of law. This has the effect that the logical consequence of a formal conception of the rule of law, that more substantive ideas around equality and justice and rights must be protected by the parliament and not the legal system, is often lost and we say avoided in the debates. So the rule of law is deployed and the conversation about whether the actual law needs to be reformed is forgotten. In this way, we try to explain how the rule of law contest in Australia reflects and is a weapon in the ideological contest between, on the one hand, the established conservative order, who tend to invoke a formalistic concept of the rule of law, in which definitions of A.V. Dicey loom large, thin conceptions are embraced, the role of Parliament is celebrated and courts are confined. And on the other hand, we see those who might threaten that status quo, using more contemporary and internationally formed conceptions of the rule of law. And these claims have seen an ascendancy in Australia with the ascendancy of global constitutionalism in the 1980s and 1990s. This second set of claims, this more substantive set of claims around rule of law, are often concomitant with claims to equality, to human rights protection, to justice. And John Tassiolis has referred to the potential expansion of such principles, such as the rule of law, the potential expansion of concepts such as the rule of law to include these broader principles as conceptual overreach. The idea that the term starts to encompass not just procedural rules, but, in his words, all the values we ideally hope the law will realise. And so Tassiolis explains that this is a power grab that might be motivated by the best of intentions, yet it distorts the very concepts in whose name it's pursued. And so he says there's a danger to this conceptual expansion. We look at this idea and see whether there's a danger to conceptual expansion in Australia, that people who promulgate such a broad definition allow those progressing a different political agenda to cloak their actions in the broader concept. And so we go back to George Orwell's idea in Politics and the English Language that some political words are almost completely lacking in meaning. They simply signify something desirable or undesirable, but in fact underneath they have these several irreconcilable meanings. And Orwell explained that words of this kind are often used in a consciously dishonest way. That is, the person who uses them has their own private definition, but allows his hearer, allows the public to think he means something quite different. Now, in a more contemporary setting, Professor Dawn Oliver in the UK context has observed that governments know that there is power in cloaking their actions in this type of positive but ambiguous language. She refers to, for instance, to the use and the deployment of the concept of public interest, but we say similar arguments can be made in relation to the rule of law. And she says it's language that will resonate with the public at large, and that governments deploy it because it conveys a generally positive meaning, even if that meaning has no consistency across the group. So we have the idea that the dueling meanings and the potential to pack too much into the concept has given rise to conceptual confusion. This leads to potential political dishonesty in the deployment of the term, accusations of insincerity when the term is deployed, and a lack of engagement about the real deeper issues that are actually occurring in the debate. And here we're picking up arguments that are being developed by Paul Burgess that invocations of the rule of law tend to be confusing, filled with good vibrations, but cloaking the actual conversation that needs to be happening. All right, so that's a long time spent of this key aim, but this is where we've spent most of the time developing the chapter that we're writing. So this key aim of our book is trying to analyse the rule of law debates as not only analytical legal debates, but rather messy, highly political and highly instrumental debates. We will explore how legal and political celebration of the rule of law in Australia provides for genuine contestations around what rule of law means, but also disingenuous invocation in the political context. Great. All right. So the second key objective of the book is to explore the rule of law in Australia by foregrounding one of the most enduring and prominent manifestations of its contest. And this is in relation to the claims to state sovereignty and rule of law in a constitutional system that has what we are referring to as an incoherent legal foundation. So the intentional ignorance of and the arbitrary violence that has been perpetrated against and continues to be perpetrated against First Nations, their sovereignty and their law. The Australian constitutional system's claim to the rule of law, we argue, must be understood as one that has its history in the coming together of the Australian Federation from colonies that were established over the top of existing legal systems, each of which had its own legal framework that was never acknowledged by these colonial systems and in many places was torn apart by colonial violence, including through massacres and attempted genocide. So the title is going to foreground this fact that the Australian legal system has this radically incoherent founding myth. And this has meant that it's delivered an unsatisfactory compromise as to the whole basis of the legal system. Of course, in Mabo, the High Court accepted, yes, there were pre-colonial legal systems undermining the claim of terra nullius on which settlement and acquisition of sovereignty was based. But the court indicated that sovereignty was of such a nature that it could not be questioned in the courts, leaving it unturned. So the very foundation of Australia's rule of law, we argue, rests on what is a legally accepted fallacy, but one which the legal and political systems have said that they do not have the capacity or the will yet to undo. This has left the status of First Nations sovereignty and law as unfinished business that threatens claims to steady rule of law in Australia. It problematises the idea that there might be a single source of legitimate lawmaking authority, which then raises the status of Indigenous law within the state. This status has been incrementally recognised in contexts from special Indigenous courts to native title and more recently in the call for a governance institution in the First Nations voice that accords with First Nations cultural, political and legal traditions. The judicial and political implications of the recognition of pre-existing laws and customs and connection to land, but ongoing denial of legal sovereignty from which these actually flow, is an ongoing crisis of legitimacy for the Australian constitutional system's claim to the rule of law. And in this respect, I should say, we draw on the thinking that we've been working with Associate Professor Ron Levy. And hi, Ron, it's great to see you here today in relation to this idea of a crisis of legitimacy. And we really thank him for his assistance in developing this concept. In addition to this initial rule of law incoherency, the book will also then explore how formal claims to the rule of law and certainty and stability deny the existence of plurally held sovereignty and the authentic practice and coexistence of First Nations laws. The book will also then try to look at how claims to the rule of law deny the lived experience of First Nations people, deny their lived experience of failures of rule of law institutions, including the police, the courts, and their democratic participation. So this is then really closely connected to our third aim, which is where I'm going to finish. The third objective of the book is to provide an extended analysis of the ways in which the rule of law experience and contests that I've already sort of set out at length manifest on the ground. So the lived experience of the rule of law. The book will absolutely undertake what you would expect, a survey of the constitutional and the legal principles and institutions that are heralded and labelled in Australia as part of our thin and thick achievement of rule of law goals. So we will look where you will expect us to look. We're going to look at constitutional protections of the rule of law, supplemented by common law protections, including, for instance, the development of the principle of legality, which is a really interesting contest, heralded by some as a real win for substantive claims to rule of law in Australia, and yet treated by others cautiously on rule of law grounds as potentially undermining certainty in the law. And we'll also look at the advancement of statutory rule of law indicators, such as new administrative law advancements, the ongoing rollout of integrity institutions and transparency regimes, and the legislative protection of rights where that exists. We also then look at the socio-political aspects of rule of law in the country. And we're going to look at how formal instantiations of rule of law, including through the development of specific accountability and oversight mechanisms and reliance on Parliament to provide more substantive rights protections, have affected the impact of law and public power on minority groups, and how their exclusion from political and legal power has also been affected. So we plan to look at sort of the chapters kind of fall in the following way. We look at how rule of law institutions, particularly constitutional protections of judicial independence, fair process rights, have failed in practice to protect particular groups, particularly those vulnerable, marginalised and publicly reviled groups. And we'll draw on some case examples in relation to refugees, terrorists, pedophiles, organised criminals and First Nations people. We're going to look at failures of government in the courts, which have undermined claims to the rule of law. Particularly, we're going to look at claims to model litigant rules and failures of government to meet model litigant standards, looking at some modern case examples in relation to robo-debt, drawing on some of Megan's work in relation to the Family is Culture report around misleading evidence in court in relation to child removals, government's conduct of native title negotiations and litigation, and some of the government's attempts to undermine the outcome of judicial decisions, looking particularly here in the national security and migration sphere, and drawing on some of the work that Anne Toomey's done in relation to the spending power. We'll look here at government's attempts to reduce access to courts, okay? So attempts to reduce access in the area of refugee law under the Migration Act, and also reducing access to the courts for environment groups and political attacks on green lawfare. How dare they use law against us? We'll look at the granting of discretions, particularly overly broad discretions to ministers and other officials, and how they can largely avoid judicial review. And there will be a section looking on delegation of legislative power, which has obviously come to the fore during the COVID-19 pandemic. We have a section that looks at the creation of integrity and transparency mechanisms that appear on their face to be rule of law promoting, but are often undermined in practice and can actually lead to a real sense that there is a veneer of rule of law achievement, particularly where governments act to strip funding, to undermine jurisdiction, and of course the exclusion of investigative agencies, politicians and judges from such regimes. There's going to be a whole section of the book in relation to corrupting interests in democracy, donation and lobbying reforms, silencing of alternative and minority voices, including through gag clauses on charities, anti-protest laws, and looking at the role of media in relation to this. And finally, we have a section on the engagement of the Australian state in international rule of law, what we call opportunism. That is inconsistent appeal to international norms that reflects Australia's diplomatic and domestic policy objectives. We'll use examples here in relation to Australia's international human rights diplomacy, both in its attempts to gain access to human rights institutions but then deny their jurisdiction in relation to findings against Australia. But also there'll be a case study in relation to Timor-Leste and the attempts to undermine recourse to international law and international jurisdiction there. All right, I'm going to leave it there, and I know that the last bit was a bit of a shopping list, so I apologise and thank you for sticking with me. I hope what I've done is given you a sense of some of the arguments we're going to try to make, but also the ambitious breadth of the project, but how we're going to try to substantiate that. I'm very interested to hear from everyone whether these arguments resonate, whether we've missed or perhaps mischaracterised some dimension of the legal or political discourse, whether we've missed a sort of glaringly obvious area of scholarship or engagement with rule of law, and whether there is, there's only so many examples we can include in the one book, but whether there's an area that you think just is a really obvious area or a really compelling area for inclusion. All right, I'm going to leave it there, and thank you for bearing with me in relation to that.
Oh, thanks very much, Gabrielle. Sounds like a really rich and exciting project, and will no doubt stimulate a number of questions. I'd like to welcome Megan. Megan missed the initial introductions. Megan, it's great to have you part of our ANU seminar series, so welcome. I'm not sure if you want to take the opportunity at the moment to add anything, or you're happy to sit and wait for the Q&A.
I think Gabrielle and I have spoken about this. I've got to jump to give a lecture to Telstra about Uluru. Okay. So I'm going to jump, but I think Gabrielle's summed up what the book is about. And if I talk more about the motivation behind the Indigenous section, I think we'll be here for a very long time. But I'll just maybe say something in 1 minute. And that is, of course, Gabrielle and I worked together across the course of 2015 to 2017 on the Uluru Dialogue. So even myself as a scholar in Indigenous people in the law was shocked by some of the things that we heard in different dialogues, both in terms of historical issues, of course, around the massacres and reprisals, a lot of which in different jurisdictions were sanctioned by law and others are not. But also some of the contemporary issues, a lot around, obviously, incarceration and youth detention, a lot to do with policing. But also right across the Uluru work, I was doing the 2-year inquiry into Aboriginal child removals in New South Wales, and Gabrielle's already alluded to it, but we were really shocked to find in our very deep dive over a two-year period into child removals, a very large number of children who'd been removed on the basis of facts lawyers lying to the court, and then the court saying that they don't have the time to check any of the evidence and the validity of the claims by caseworkers. And so as a consequence of that, we had a very large number of young people and children who were removed without cause. And they have the same problem in other jurisdictions, such as they did in Queensland up until the Carmody inquiry, at least, where they found the same thing was happening. So what they did was they separated out the lawyers, meaning they put some of the lawyers into attorney generals and they check the work of child safety officers before it goes before the court. But that's caused all sorts of tension between the two groups of lawyers. But the point is, it's well known right across the Federation that this is occurring, and it's precisely what the Grandmothers Against Removal have been telling everybody, but people didn't believe them until we did the deep dive. So there's a lot of other examples, of course, including youth detention in particular, where we see a lot of lawful, unlawful behaviour. But they're just some examples of why we started to really talk about, on top of all the many issues that Gabrielle grapples with, the problematic conceptual framing of the rule of law in Australia. But I'll shut up there, James, because I will go on forever, and I better jump over to Telstra.
Okay. All right, Megan, thanks so much. Okay, thanks so much. Look, I might open it up for questions from the group. I might get the ball rolling then. It was just in relation to the third key objective of the project. It sounds like it could become, on paper and no doubt in reality, a massive undertaking. I just wondered what the thinking process was in terms of refining the areas, identifying the areas that you wanted to explore and cover in the book. Or have you just decided to go for everything?
Go for broke. No, look, I think it's been a bit of a process. We went for broke when we initially scoped the breadth of that particular part of the book and achieving that objective. But how we've actually narrowed it and we're trying to contain it is through this frame of looking at previously excluded interests or vulnerable or publicly reviled groups, and taking them as a group within the community where the law can often fall most harshly, but they can also be excluded from law and also then the political systems, and trying to use them as our case studies to drive the mapping kind of exercise that we're trying to do in that third part. So we do want to have the breadth, but then we're going to use case examples to kind of keep it coherent and narrowed. That's the aim, though. Who knows when it falls out? But yeah, no, that's been the process behind it, because I think you're absolutely right, James. It has the potential to become very unwieldy very quickly. And the intention of the book is not to be unwieldy, but actually be a comparative title that people who are picking this up, as probably legal or political scholars from other jurisdictions can get a sense of what's happening in Australia. Yeah. And if it's too unwieldy, they won't get that.
Yeah, great. To Leighton and then Wayne.
Thanks, Gabrielle, and also Megan. This project sounds really fantastic. My question, Gabrielle, does relate to the first sort of arguments you're making about how the rule of law is used descriptively in politics and legal discourse in Australia. And correct me if I'm wrong about this, but I thought you were saying that in the book you were trying to get past yet another normative account of what the rule of law should mean, and then to proceed to evaluating a particular legal domain, or in this case, particular national jurisdiction, by reference to whether or not it lives up to that normative account. And I guess my question is whether or not you can really do that, whether or not you can get away from some sort of an attachment to a normative account of the rule of law. So it strikes me when you look at how descriptively the rule of law is being deployed in argument in Australia, you're confirming a risk that Judith Squire wrote about in an old paper now about the rule of law being subject to ideological abuse and overuse. I think that's an ever-present risk. And if you go down that line, and if you say in Australia the deployment of the rule of law is just cover, it's just cover for hiding, you know, on the right, you might say the rule of law has long been used to be some sort of bulwark against the encroachment of the welfare state. And on the left now, in some circles, although there's a lot of diversity in this, but in some circles, you have progressive lawyers trying to look to the courts through capacious uses of the rule of law to get things they couldn't get through legislatures. So if everyone is using the rule of law strategically or ideologically in this way, isn't the natural conclusion to say, well, let's talk about what really matters here. This language should be junked. Perhaps there's a place for the legal philosophers to keep going on about it, but at least when you get it deployed in courtrooms, in parliaments, in media releases, all of that stuff, it doesn't help us. So the question really, sorry, this question's been way too long, but the question, I guess, is once you start looking at the legal institutions in the third part of the book, don't you have to be talking about something there to evaluate their contribution to the rule of law? I don't know if that made sense.
No, it does, because that connection between the first objective and the third objective, I think, is the hardest part, because how you've kind of described what we're doing in the first part of the book, I think is pretty accurate, and we're trying to really tease out the different ways in which, you know, to put bluntly, the left and the right have been using rule of law, how it's manifesting particularly in Australia because of how historical context, et cetera, and so that part I think we can do with being pretty coherent with our objective of not having a normative yardstick, right? And that's where I've been, as I said, that's the chapters I'm writing that we're writing at the moment, and that's what we're talking about at the moment. So I'm feeling pretty confident about that. Once it comes to, well, what's the lived experience of the rule of law? Well, what conception of rule of law are we talking about? So that's the real challenge for us. So you've totally identified, you know, a potential incoherency in the book. One of the ways that I've been trying to navigate that is to look at areas which have been identified in debates and be clear about who has been identifying particular principles or institutions as being part of our rule of law, you know, part of our lived rule of law in Australia. So, you know, constitutional protections of judicial independence and fair process, Chapter 3, even our kind of thin rule of law proponents would say that's a really important part of constitutional protections of rule of law. And so the lived experience says, okay, well, if that's true, are we actually getting that? Are we even getting that? Right, and then using those case examples to demonstrate, you know, James knows better than anyone whether or not particular groups are actually receiving the benefits of those protections or not. So it's kind of taking the claims that we map in the first part and saying, well, if you take this conception of rule of law and you include these institutions, what's happening on the ground? Are they even living up to those expectations? Now, there's going to get to chapters where there is going to be more substantive dimensions of the rule of law achievements in Australia. And again, so that they're sort of taking different yardsticks as we go through the different examples and case studies. That's how we're currently trying to navigate that incoherency. Whether we're able to do it successfully and convincingly or not remains to be seen. But thanks, Leighton. That's great.
Thanks, Gabrielle. That's great.
So Wayne and then Dinah, and I think Don after that.
Thanks, James, and thanks, Gabrielle. Yeah, it certainly sounds like a fascinating and weighty tome. Look, as you were speaking, particularly about the first two sections of the book, it really struck me the extent to which, although you didn't make this explicit, you're drawing on, numerous critical theories and discourse analysis. And I wondered to what extent you were going to make that sort of explicit in the book. Feminist theory, critical race theory, critical legal theory generally, and that very much sort of mining genealogies of the use of the concept of the rule of law in discourse, which it seems to me to some extent is what you're doing in the two sections of the book. And even to some extent, different conceptions of power. So, dare I bring in sort of some Foucauldian sort of concepts of juridical versus disciplinary, etc. So, yeah, I just wondered, is that an explicit sort of set of theories that you intend to draw on?
So interesting that you asked that question, Wayne, and hi, it's lovely to see you again. We hadn't yet brought it explicitly to the fore in our thinking and conversations, I think is the response to you. Although we certainly have this sort of objective around the genealogical mapping of rule of law discourse. But I was reading just yesterday Geoffrey de Q. Walker again, and his engagement with critical discourses really was just sort of smacking me in the face that this is something we need to do. So you've now smacked me in the face again, and I think, yes, it is something we need to look at, and thank you for that suggestion.
Not at all a smack in the face, but it just, the synergies.
A very welcome one.
The synergies seem to be, explicitly there. I'll shut up now. Yeah.
That's terrific. Thank you.
Okay, Dinah.
Thank you. Thank you, Gabrielle, and to Megan. That was fantastic, and I'm looking forward to reading it. So my question was about the political uses of the rule of law as well. And my question was, so let's say in the thing, both you and Leighton mentioned, the right thinks rule of law means not restricting property. The left means, winning political battles you can't win right now in elections. And I was wondering, to an extent, this sounds to me that it encapsulates rule of law invocations well beyond Australia, right? Like that seems to me to be the standard way. So my question was, do you think there is something distinct about this political mapping in Australia? There is something that differentiates it from other Anglo contexts? And more broadly, whether this is something you will address in the book, whether, there is a transnational dimension there, not necessarily comparative constitutional, but there is some sort of like transnational gatherings of how people deal with the rule of law, and if that's within your remit of analysis.
Yes, excellent question and provocation for us. So I think there is absolutely something that's transnational about the point we're trying to make. And I think, some of the work that we're drawing upon to illustrate what's happening in Australia is transnational in its description or scope. We are trying to explain specifically how that's manifesting in Australia and as manifested at different times based on the particular historical context and how it manifests particularly in Australia in relation to the political, legal constitutionalism sort of tension. Which is of a particular balance in Australia. But I think, the series intention is comparativist. So to have an Australian title in a series where all the other authors are being asked the same question, but then for us to tap into transnational debates within individual titles will be an important part of that comparativism. And I also, I was provoked by my partner who this idea of the incoherent founding myth in relation to the state's relationship with First Peoples. You know, he was pushing me, you know, that this isn't unique to Australia. And I was pushing back and saying, but it's the particular way in which it's carried out and its manifestation, there is a uniqueness to the context of Australia. So we are trying to both draw into the broader debates and then also to highlight how it's happened in Australia.
Thank you.
Thanks.
And Dom.
Question I had was about that crisis of legitimacy point, and how you are, and whether and how you're going to weave that through the three different parts of the work that you're contemplating, because that seems to me to be pretty fundamental if what you're arguing is that the very foundations of the Australian state have this unfinished business, and theoretically that could trickle through to all of the different manifestations of the way in which the rule of law is used in Australia. So maybe I'm seeing a causal connection that you don't see or aren't intending to see, but I'm just wondering if that's something you're planning to, another idea you're planning to draw out of the book as it proceeds through its three parts.
Thanks, Dom, and it's also lovely to see you. I haven't seen you for so long. Yeah, look, it is absolutely something that we want to explore whether it does, we think it does, but how it is having effects across legal, political dimensions of different parts of the experience of the Australian constitutional system. I'm going to be honest and say that we have, I've done some amazing work with Ron exploring it in relation to the proposed reform around the First Nations voice, but as yet we haven't really looked at it in depth in terms of its trickle-down effect, or its more kind of omnipresent effect, if you will. The intention is to explore it, but we haven't done it yet. We've been focusing our attention on these first few chapters, but hopefully I'll have a better answer for you in about 6 months' time.
Oh, look, you're doing so much with the book, and it was cheeky of me to say, and are you taking it in this direction? I mean, I'm interested in everything that you're doing, but that in particular, because it just seems to me that if you're arguing that's foundational, and if it's foundational, then it must have flow-on effects. It's also going to affect the majoritarian tinge to the political in a very obvious way. And again, that's another sort of thread you could potentially emphasise. But I suspect, as most of the people here have, listening to what you're doing, have deduced, one of the problems you're going to have, I think, is working out where to put your emphasis, because there's just so much in what you're planning to do, and it could go in so many different directions.
Yeah, great.
Yeah, thank you, Dom.
That's really helpful. Thanks, Dom.
Oh, well, look, that's terrific. We've reached the hour, so I think I might bring things to an end. It's really just for me to give my thanks. Gabrielle and Megan are really great friends to the College of Law, and we're delighted to have you join us in our faculty seminar. Sounds like a really wonderful project. Thanks for the hour of stimulation that you've provided to us over lunchtime. We wish you well with the project, and personally, I hope to see you at some point very soon.
Thank you so much, James. Thank you, everyone. And I really hope I can see you all in person someday soon. It feels like it has been way, way too long. But thank you for your time and your ideas. It's been wonderful.
Thanks, Gabrielle. And thanks, everybody else, for joining in over lunchtime.